Myself, Suganya VS. I completed MCOM MPhil. I am working as a assistant professor in Department of Commerce at St. Josephs College of Arts and Science for Women. I am going to talk about 2 Introduction to Industrial Dispute Act 1947. Introduction. The Industrial Disputes Act 1947 is the legalization for investigation and settlement of all industrial disputes. Introduction. Industrial disputes are the disputes which arise due to any disagreement in an industrial relation. Industrial relation involves various aspects of interactions between the employer and the employees. In such relations, whenever there is a clash of interest, it may result dissatisfaction for either of the parties involved and hence lead to industrial disputes or conflicts. These disputes may take various forms such as protest, strikes, demonstrations, lockout, retrenchment, dismissal of workers, etc. Industrial Disputes Act 1947 provides machinery for peaceful resolution of disputes and to promote harmonious relation between employers and workers. The act is began measures which seeks to preempt industrial tensions, provide the machines of disputes resolution and set up the necessary infrastructure so that the energies of partners in production may not to be dissipated in counterproductive battles, and assurance of industrial may create a congenial climate. Objectives and significance of the Act. The Industrial Disputes Act 1947 makes provision for the investigation and settlement of industrial disputes and for certain other purpose. It ensures progress of industry by bringing about harmony and cordial relationship between the employers and employees. Definition of the words industrial disputes, workman and industry carry specific meaning under the Act and provide the framework for the application of the. In the case of workmen of Dimakuchi Tea Estate versus Dimakuchi Tea Estate, AIR 1958 SC 353, the Supreme Court laid down following objectives of the Act: promotion of measures of securing and preserving amenities and good relationship between employer and workman, investigation and settlement of industrial disputes between employers and employers, employers and workmen or workmen, and workmen with the right representation by registered trade union or federation of trade unions or an association of employers or a federation of associations of employers, prevention of legal strikes and lockouts, relief to workmen in the matter of layoff and retrenchment, promotion of collective bargaining. Industry. What is a industry? Industry means any business, trade, undertaking, manufacturer or calling of employers and includes any calling service, employment, handicraft and industrial occupation or avocation of workmen. Section 2, subsection 1. Industrial disputes. Industrial dispute means any dispute or difference between employers and employers, or between employers and workmen, or between workman and workman, which is connected with the employment or non-employment, or the terms of employment, or with the conditions of labor of any person. Section 2, subsection. The above definition can be analyzed and discussed under the following heads. There should exist a dispute or difference. The dispute or difference should be between employer and employer. B1. Employer and workman, or workman and workman. The dispute or difference should be connected with the employment or non-employment, or terms of employment, or the condition of labor of any person. Last one, the dispute should related to an industry as defined. Section 2, subsection J. Collective bargaining. Collective bargaining is a process of negotiation between employers and a group of employees aimed at agreement to regulate working salaries, working conditions, benefits, and other aspects of workers, compensation and rights for workers. The interests of the employees are commonly presented by representatives of trade union to which the employees belong. The collective agreements reached by these negotiations usually set out wage scale, working hours, training, health, safety, overtime, grievance mechanisms, and rights to participate in workplaces or company affairs. Strike. General meaning. A strike is a powerful weapon used by trade unions or other associations or workers to put across their demands, grievances by employers or management of industries. In another way, it's a stoppage of work caused by the mass refusal. In response to grievance, workers put measures on the employers by refusal to work till fulfillment of their demand. Strikes may be fruitful for workers' welfare, or it may cause economic losses to the type of strikes. Stay in, sit down, pen down or tool down strike, go slow, hunger strike. The legality of strike is determined with reference to legal provisions enumerated in the Act and the purpose for which the strike was declared is not relevant in directing the legality. Section 10, subsection 3. Section A, subsection 4A, 22 and 23 of the Act deals with the strike. Section 22 and 23 impose restrictions on the commencement of strike, while Section 10, subsection 3 and 10A, subsection 4A prohibit its continuance. Lockout. Lockout means the temporary closing of a place of employment, or the suspension of work, or the refusal by an employer to continue to employ and number of person employed by him. Section 2 subsection I. Lockout is an antithesis to strike. Just as strike is a weapon available to employees for enforcing their industrial demands, a lockout is a weapon available to the employer and pursued by a coercive process the employees to see his point of view and accept to his layoff. Layoff means the failure, refusal, or inability of the employer to give employment due to following reason to a workman whose name appear on the muster roll of his industrial establishment and who has not yet retrenchment, shortage of coal, power, or raw materials, or accumulation of stocks, or breakdown of machineries, or natural calamity, or for any other connected reason. Retrenchment. Retrenchment means the termination by the employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by a way disciplinary action, but does not include volunteer retirement of the workman, or reaching of age superannuation if the contract of employment between the employer and the workman concerned contains and stipulation in the behalf or termination of the service of the workman as a result of the non-renewal of the contract of employment between the employer and the workman concerned on its expiry or of such contract being terminated under the stipulation in that behave contained therein, termination of the service of workmen on the ground of continued ill health. Authorities under the Act. The Act provides for following authorities for investigation and settlement of industrial disputes: Work Committee, Conciliation Officers, Board of Conciliation, Court of Inquiry, Labour Court, Industrial Tribunal, and National Tribunal. Thank you.